Thank you very much to the organisers for giving me the honour of addressing you this afternoon. I'm not really so very distinguished, but I hope this will make me so. The title of my address this afternoon is The Age of Empire, again, question mark. It's not that I've talked about the Age of Empire before, but I'm exploring whether, in fact, legal education is taking us back to that moment in time. For comparative scholars, the title of my paper might be seen as offering attractive opportunities. For where would we be without the various ages of empire? Romanists and those who study legal systems in which Roman law, either in its original or glossed form, is a part, would be bereft. Civil law systems affected by the imposition or adoption of the Napoleonic Code would be stripped of many of the characteristics which today continue to make them distinct. And the common law would not have travelled to its present outposts in the way that it did. Legal imperialism is therefore something which contributes to the rich tapestry of the world's legal systems, and the consequences thereof are the lifeblood of comparative scholars. Purists, of course, may argue differently, holding out against legal transplants, the adoption of alien laws, and foreign concepts. While those fighting the corner of mixed or hybrid legal systems in danger of being overwhelmed by a dominant force might attribute responsibility to legal imperialism. What I want to focus on here this afternoon is a form of legal imperialism which is not in itself new, but is manifesting itself in new ways through legal education. I've struggled to find in contemporary literature, particularly by comparativists, the impact and importance of legal education and the training of lawyers and judges. Often it's implicit rather than explicit. However, given the mobility of students, and in the UK at least, an increasing emphasis on recruiting overseas students, this seems to me to be an important field of inquiry. So in this paper, I propose to consider the potential significance of legal education. And here I have in mind the academic stages of legal education rather than the postgraduate academic or vocational stages of legal education. And what I'm looking at is legal education as a foreign transplant and the role that comparativists might play in the context of contemporary trends in that legal education. It is, of course, well known that one way in which new legal ideas circulated was by scholars and lawyers travelling abroad to study at foreign universities. For example, in Scotland, where I was until fairly recently, Scottish lawyers in the 16th century received most of their legal education in the Netherlands and later in France, and brought it back to Scotland, thereby establishing what is regarded as a mixed jurisdiction of common and civil law with small elements of customary law. This process has continued on and off over the centuries, not just in Scotland, but elsewhere. So, for example, under colonial rule, scholarships were awarded to bright students from India and Africa and others, and they came to England to study, while today many undergraduates study abroad under Erasmus and other programs. Sometimes these scholars return to their home country to take up significant posts as leading lawyers, judges, or government advisors. Sometimes, of course, they do not return. The ebb and flow of scholars and scholarship has contributed much to the development and survival of comparative law and comparative legal method, and indeed is illustrated at this conference in the topics and nationalities of various speakers presenting over the next couple of days. Conscious of the globalization of law, there is an increasing emphasis on international law, and in some universities, greater emphasis on transnational law or on studying foreign laws within the curriculum, and or preparing lawyers for global legal practice. I think my slides have frozen. It's easy to use now. Oh, would you like to stay and do the magic? However, it's been at least suggested in the Canadian context, and this slide indicates that the drive towards greater international and foreign content in legal education has, while continuing unabated, been somewhat ad hoc and unplanned. Little attention has been paid to whether and how some of the developments in legal education might fit into some overall consistent pedagogical vision. So what I want to focus on here is the export of the English common law curriculum and its significance from a comparative law perspective. With advances in technology, it is increasingly possible for those living abroad to study with an institution located elsewhere through distance or mixed media learning programs. Originally, these distance learning programs were designed to serve students who, due to reasons of distance, cost, or other commitments, could not attend university. Today, such programs are no longer constrained by erratic postal services and can have much greater outreach. Examples that come to mind, and which I myself have experienced, are the Open University in the UK and the University of South Africa based in Pretoria, UNISA. And when I was working in the South Pacific, the University of the South Pacific, which relied initially entirely on a very erratic postal system, as exam papers had to come by boat or canoe. But today it's not only those institutions which started out with the aim of offering distance courses that now participate in this market. In the UK, a great many universities, many of which are relatively new universities, now offer mixed mode delivery. I had a very obliging PhD student who did some research for me, looking at the universities that feature in the top 20 of UK universities attracting international students. And this is a report by The Guardian, which has Oxford Brookes at the top and the University of Manchester at the bottom in terms of the top 20. That's not to say that there aren't a great many more universities attracting international students, students who are studying wholly overseas. So they're not in the UK, they're studying wholly overseas. So this is quite a big number of students that are studying. And it was this particular table that then prompted further research and part of this paper. The bulk of these overseas or international students are distance learning students. But there are also those who are studying at local institutions in their home country, which are linked to a UK university by franchising or partnership agreements, under which the UK university accredits courses and awards named degrees. The UK university may also provide teaching staff, perhaps on a permanent or rotational basis, and quite often nationals of the country may have studied at the UK university and then go home and become part of this franchised or partnership delivery of education. There are also, although less usually and certainly less numeric, overseas campuses of UK institutions being established, which are not partnerships and are not agencies, but are part of the home institution. So campuses that actually belong to the UK institution are being rooted in foreign soil. Quite often they're funded distinctly from a home institution, usually by fee paying, possibly by some kind of regional sponsorship or collaboration with the national government of where they are rooted. Research indicates that at least 15 UK universities which offer law degrees have established campuses outside the UK, often in more than one country. Now, this doesn't necessarily mean that all these campuses offer law, but to give you one example, the University of Nottingham has a presence in China and Malaysia. Newcastle University has a presence in Malaysia and Singapore. So the research looked at this list of universities that have the most students studying overseas and then looked to see how many of them had actually put down roots outside of the UK. There are, however, at least 3 UK universities that are offering undergraduate law programs at their overseas campuses. While I have a number of reservations about the teaching of law courses based almost solely on national legal systems to foreign students, especially when these courses extend to or include professional courses, my greater concern from a comparatives point of view lies with the export of legal programs as wholesale transplants to foreign soil. While this practice of establishing a UK campus to teach English common law on foreign soil is not yet extensive, it does appear to be on the increase. And it concerns me because through this physical presence, and perhaps through the employment of local nationals, this export of education, legal education, is a foreign transplant. And unless adapted or adaptable to the local legal environment, the question arises as to whether these transplants could potentially pose a future threat to the integrity and possible sovereignty of national legal systems. It is, of course, the case that the common law spread far and wide as a result of the expansion of empire and the imposition of its laws during that period. And a number of lawyers from the colonies received their legal training in the UK and returned to practice in their home countries, cloaked in the common law. And of course, some of them went on to become well-known judges. It's also the case that the common law judges still sit on some benches of appeal for some of the world's smallest jurisdictions, and that there are still jurisdictions that retain the Judicial Committee of the Privy Council as the final court of appeal. The common law continues, therefore, to be a legal export. However, when former colonies became independent, although many legal transplants were retained, there was also the opportunity to excise them, to reassert other legal forms and values, and to develop distinctively national legal systems. One consequence with which comparativists are fairly familiar was that many former colonies have plural legal systems today, which recognise, besides the common law, civil law, religious law, and customary law. So that to practice in such a country, it is important to understand the relationship between these laws and to appreciate the complexity of the legal system as a whole, as well as the cultural, social, economic, and political context in which it operates. Key to this understanding is the content and form of legal education. So the question arises, what are the possible consequences of exporting a common law education to non-common law countries, either through delivery at a distance or through campuses set up on foreign soil? So my question is, are we looking at a Trojan horse? A Trojan horse of legal education? Of course, the question that I've just posed as to what are the possible consequences could be asked of all international students who either never leave their own country but study at a distance, or those who travel to study abroad and then return to their home country. But it is particularly pertinent in the case of exported legal education, especially when that export is transplanted to a legal system which may be vulnerable to exogenous influences. The reason why I identify some countries as more vulnerable than others is that at present, offshore campuses appear to be being set up in jurisdictions which, as the result of colonialism and its legal legacy, are regarded as plural, mixed, or hybrid. I'm not going to depart into the categorization of such systems, only to say that when I'm using that term with which comparative lawyers will be familiar, I'm using it in a non-classical sense and in a rather broad sense. So I adopt the listing adopted by Mariani and Fuentes, to which Palmer refers, which suggests that there are 10 possible mixes for mixed legal jurisdictions. And they suggest these ones. This particular categorization, of course, provides a much broader palette of mixed jurisdictions. For the purposes of my presentation, I want to point out that within this list we find India, China, Singapore, Cyprus, and Mauritius. And I single these out because it is in these jurisdictions that the greatest transplant of legal education appears to be taking place. Of course, this isn't to say that all transplants of legal education are necessarily a bad thing. It may not be of great concern where the subject matter of the legal education is not jurisdiction specific, but global or international, and where, therefore, the exchange and movement of scholars as teachers and students is an integral part of the harmonisation of law across national boundaries, or the recognition of a shared global legal environment. And here, intellectual mobility has much to recommend it. Of greater concern is where this legal education is more general and extends to subject areas where comparative and plural insights into the jurisdiction may be regarded, at the very least, as desirable if not essential. This, it could be argued, is the case even where transplants are being embraced or actively sought. For example, in China, there is an apparent willingness to look across Europe for models which may be best transplanted to suit the new market economy of China. But these imports by China are not limited to the common law. It extends to other systems, for example, the adoption of principles from German civil law. Moreover, although there may be a perceived shift towards Western laws, the legacy of combined philosophies of Confucianism and communism create a very different idea about the rule and role of law from those underpinning the common law. And this creates very different ideas about the rule and role of law as taught in perhaps English law schools. And this difference should not be overlooked. Indeed, it's been suggested by one Chinese academic that in order to understand the legal system of China, and he also refers to Japan, that a lawyer or anybody practicing or encountering the law must know the different attitudes towards Western influence going back to the 19th century and some of the philosophies that have informed Chinese thinking since then. And he concludes this quote by saying that the Chinese actually prefer poetry and calligraphy and painting and money to law, even if on the surface it appears different. So that very basic difference in perception, it may be something that underpins the whole of the legal system and is a subtle and nuanced dimension that perhaps those trying to teach law to Chinese students and Chinese lawyers trying to practice in China need to know about. Similarly, in India, where the common law has had considerable influence, it should not be overlooked that for centuries it had lived alongside and has had to accommodate the diverse religious laws that exist in that country ever since the British East India Company first established courts under its royal charter in the 17th century. And the same writer suggests that in order to understand the legal system of India, you need to know a great deal more than just the common law. For the purposes of this particular paper, I wanted to focus particularly on 3 island states. Island states because I like islands, and these states because they're mixed legal systems. And the 3 states that I've chosen are Singapore, Cyprus, and Mauritius, largely because this is where campuses are being established, and because their legal systems particularly illustrate my concerns. These are all mixed legal systems. And I would suggest that because of the features of these legal systems, any legal education that is offered to those hoping to become lawyers or become involved in the law in those countries needs to be customized so as to provide practitioners or others with the appropriate knowledge and skills that are required for functioning within a mixed legal system. Otherwise, there is a risk, either by omission or commission, that over a period of time, certain aspects of the legal system will become endangered. Of course, legal education will only be one of many factors that might create that endangered species status. Nevertheless, I think it is something that should attract attention. what I've highlighted, perhaps not very legibly against the flag of empire, is that in Singapore, it might be thought that really it doesn't matter if a person practicing law in Singapore receives the whole of their education in English common law, given that the British East India Company introduced the common law for its employees in 1819, when Sir Thomas Stamford Raffles first established a trading port there. However, Singapore also has a number of different languages besides English and a number of different religions, and it has to accommodate those within its legal system. So the Singapore legal system is not just a common law legal system. Chinese, Malay and Hindu law have long been recognized, particularly in areas of personal law. And indeed, all legislation that goes through the Singapore Parliament has to be submitted to a minorities committee for scrutiny to ensure that the impact of any proposed law does not adversely discriminate against any of the religious minorities of the country. Also, while the common law may be a dominant source in Singapore, it is not the only one. Particularly, it is not the only source that influences contemporary jurisdiction, because Singapore judges frequently look to other common law sources such as Australia and New Zealand, and not merely back to the UK. So Singapore lawyers need to know about the pluralities of their own legal system, as well as having a sound grasp of what I would call comparative common law. Similarly, Cyprus has a very mixed legal system. Indeed, it's been described as a colourful plurilegal mosaic, and it combines elements of common law, civil law, and religious law. And even the common law that was introduced into Cyprus is not purely that from the UK, because under British rule, a number of models drawn from other colonies or other parts of empire at the time were introduced, notably the law of sale of goods from India. And as we see, India has its own legal system. Although when it became independent in 1960, the laws in Cyprus remained in force, it wasn't clear what those laws were entirely, or whether post-1960 laws from England and Wales still apply. It's also the case that the language of the court in Cyprus has become increasingly Greek or Cypriot rather than English, and with the advent of the law school in Cyprus, at the University of Cyprus in 2005, those wishing to practice in Cyprus do not have to go to Greece or to England to study law anymore. They can stay at home and study in Cypriot and study Cypriot law. They may also go to Greece. So increasingly there has been a shift in contemporary times away from the common law or administered in English to Cypriot law administered in Cypriot, with influences from Greece particularly, but also France in administrative law becoming increasingly important, as well as the retention of various forms of religious law. And then finally, my final island mixed system is Mauritius, which is a unique hybrid of laws, strongly influenced by the French law from the adaptation of the Custom of Paris in the 18th century through to the Napoleonic Code in 1808, and then under English imperial influence, English common law. However, despite the long period of British rule, French civil law was retained, and in 1992 Mauritius adopted a French-style constitution, becoming a republic. The resilience of French civil law in Mauritius has been assisted by the retention of French as the language of the legal authorities which are referred to, even though the language of the courts is English. So the jurisprudence that Mauritians can refer to comes from the French Cour d'appel and the Cour de cassation, which are some of the leading authorities that lawyers need to know about. the legal profession is not a binary one, but it follows the French model of distinguishing between notaries, advocates, and attorneys, so that a Mauritian student taught in common law with the view of becoming a solicitor will have a very misguided idea as to the tasks that solicitors might do when they get back to Mauritius. It's also the case in Mauritius that although lawyers used to be trained abroad in France or in England, since 1985 the University of Mauritius has had its own law school where students receive a bilingual legal education and a mixed legal education, so that a distinctively Mauritian mixed legal system has been developed. Now, I give you a brief snapshot of those three mixed legal systems to suggest that lawyers need a customized form of legal education, such as that is being offered in the national law schools of these countries, rather than perhaps an exported model. So that if a model is offered, then it needs to do considerably more than what it might do in the UK if it is to satisfy the needs. And if it does not, then there may be adverse consequences. This claim is, of course, premised on the assumption that legal education plays a significant role in the formation, survival, and development of legal systems. Now, I would suggest that it does. And so I've placed it in the center of my diagram because it seems to me that from legal education stems other things, and into legal education flows various things. So if one looks at the sources of law, those flow through into legal education because that's what we teach students about. And those who inform those sources of law, judges and lawyers, come out of legal education. It's also to do with the language in which the law is delivered, and the way in which lawyers think will depend on how they are taught. This is one of the ongoing arguments I have with Scottish colleagues who always assure me that Scots lawyers think differently from English lawyers. And I say, okay, so how do they think? Well, they think differently. Right. They think in tartan, and we don't. It might be difficult to quantify the significance of legal education in a legal system, but certainly its relevance and the language of that education has long been recognized by academics. For example, Arucha has stated that the factors in maintaining a legal tradition generally referred to are shared language and terminology, legal education, and legal literature. Tetley in Scotland has drawn attention to the contribution that universities can make to the enrichment of legal culture and the advancement of mixed jurisdictions and their respective linguistic heritage. Both Arucha and Tetley refer to the importance of language, and Vernon Palmer has pointed out that one of the real threats to the survival of a mixed legal system is a disappearing literacy in the source language of the civil law. Even in India, Hooker has attributed the deformation of Hindu law to the process of English law, pointing out that even where due care and attention was paid to the importing English concepts, the use of the English language was itself an element of distortion. So, delivering legal education in a language other than the one used in court, or without any reference to other languages which might be relevant, undermines the integrity of the existing mix of any mixed legal system. Hence the importance of the bilingual legal education being offered in Mauritius, the shift to studying in Cypriot or Greek in Cyprus, and other initiatives. There is also the problem that the language of the law and of the lawyer is itself distinct from everyday language, or the language of the non-lawyer. The words used in law convey certain legal concepts which lie behind them, and not all are easily translated. Take, for example, the English word cause, as in causation, and the French word cause, as used in the law of contract. They sound and spell the same, except if you're French or you're English. then they're different. Barbara Posey has stated that language is essential to the process of acquiring knowledge of foreign law. There are therefore two concerns. One is the loss or absence of linguistic skills to acquire that knowledge. The other is the acquisition of a language competence which is limited to legal language and therefore incomprehensible to non-lawyers. So there's a danger of the limited language competent lawyer being distanced from the realities of everyday life, including the lives of clients and corresponding problems for communication. Of course, not all mixed jurisdictions are multilingual and may not need to be. Some, however, may be multi or dual lingual for some purposes, but not others. So the language of education may not necessarily be the only language of everyday speech. Even where English is already the domestic language of legal education, there are still dangers. T.B. Smith, a Scottish purist, pointed out that in mixed legal systems which use English as the language of the courts are particularly exposed to subversion through the imposition or incautious acceptance of technical terms of Anglo-American common law as equivalent to civilian concepts. So this may occur even where the mixed system is not a straightforward mix of civil and common law. So that where national systems have gradually emerged through the adaptation of introduced principles under empire and concepts to local circumstances, nuances may be ignored or rejected by lawyers immersed in a foreign legal education, whether as learners or as teachers. Even if the language of the courts is in English, the language of the legal sources may not be, as indicated in Mauritius. So loss of language means loss of access to these resources, whether they are historic or contemporary. And that in turn may lead to loss of breadth of understanding and a limitation on the authorities that can be cited in legal argument. While this may be overcome by an increasing body of work by comparative legal scholars in English, this still requires a legal education which teaches the importance of these diverse sources. So what is the significance of this new form of legal imperialism to comparative legal scholars? Comparative lawyers are well aware of the blending effect of international law and nearer to home European law. And indeed, at one point, the harmonisation of laws was one of the objects of early comparative scholars, particularly around the start of the 20th century. Others, however, may see creeping internationalism as the death knell of comparative legal study. Of course, it could be questioned whether it is the role of comparative lawyers to expose the Trojan horse of legal education. After all, presumably, host countries have agreed to the export of legal education or the nurturing of it on foreign soil. And no doubt the degrees that are being offered or the courses that are being offered have to go through some kind of rigorous accreditation and QAA investigation. It's also a case that in an era where higher education, including legal education, is increasingly consumer-orientated, then this is just a question of supply and demand. And that it really is rather pointless, particularly given the agendas of some of our management in universities, to raise concerns about the ethics or efficacy of transplanted legal education. And we will be met probably with the perfectly valid argument that this is quality education on offer to those who couldn't otherwise access it. There's also, of course, the potential for valuable comparative legal research and collaborative ventures, as well as the opportunity for scholars from both sides to be immersed in a foreign legal system so as to be able to return to their own system with open eyes and a chance to see things more clearly from a comparative perspective. Conversely, should comparative lawyers alert both sides to the debate about legal transplants? Should they draw attention to the strengths and vulnerabilities of mixed systems, to ideas about the formation and survival of indigenous legal systems and to the challenges for lawyering that plural legal systems might pose. Indeed, does this development in higher education provide an opportunity for the practical application of comparative legal studies, either in informing the development and design of appropriate legal education for export purposes, or in educating those who propose to offer such programs? In some countries, legal systems which maybe are more attuned to the importance of legal education for a polyjural, multicultural environment, this happens, for example, in Canada. However, among those institutions with large numbers of overseas students or which have campuses established outside the UK, my research suggests that there is rather less evidence of recognition of the polyjural or multicultural context of law. A review of the institutions listed in the first chart of the 20 universities with the most overseas students indicated that very few offer comparative legal studies or the integration of the study of a foreign legal system within the standard undergraduate LLB curriculum. Indeed, if one discounts the University of London, leaving 20 universities in the table, only 2 offer law and foreign law, and that's usually something like English law and French law, or English law and German law. 2 offer comparative Islamic studies, and 1 offers an option in comparative law. This is at undergraduate level. At postgraduate level, again leaving out University of London, particularly SOAS, then the situation is similarly pretty dismal, despite the fact that at a postgraduate level there are far fewer constraints on what you can offer in the curriculum than at the undergraduate level, where the professional bodies somewhat regulate what has to be taken. Now, this isn't to say that there aren't other niches of comparative law being offered, but I'm looking at the ones that recruit large numbers of overseas students. So, as emphasized in these 2 quotes, even if common law is an important influence in the internationalization and globalization of law that students, if they become lawyers or go into professional practice or into commerce in some way, may need to know about, there are still differences. There are still nuances that need to be recognized. And as Tam suggests, people of different cultures actually do think differently, even if it may look that the law is the same. Behind what is apparently unity or harmony, and which is often conceived as such, there are still important differences, and these differences are important to acknowledge. The problem is, and the second quote is from Valk, who's writing about Canada, that there is very little institutional reflection on comparative law teaching, particularly against this current climate of recruitment of overseas students. Although there is, I would suggest, opportunity. One of the problems, of course, is that pragmatic considerations may outweigh or trump pedagogic ones. For example, particular initiatives may be planned and decided with very little localized input on both sides. They may be secured by memorandums of understanding or bilateral contracts between senior figures of universities who are not always academics and governments or private funders. Timeframes may be very short, or political and economic considerations prevail over academic ones, suggesting that a comparative analysis of the merits and demerits of any proposal or consideration as to how a program of comparative and or transnational legal education might support such a project is likely to fall on deaf ears. My own experience recently was that an email came round saying that the institution had been approached to offer professional legal education to somewhere in Africa. And I said, are you sure that what we do here is going to be transplantable to this particular African country? Should you not perhaps know something about their perceived needs, facilities, resources, and perception of ethics? I was rather swiftly dismissed as being a thorn in the flesh And if people were going to have ideas like that, then they should not use the email. Because time was of the essence. Somebody wanted to have a commitment from the institution that, yes, we were interested. I said we shouldn't be interested unless we knew a little more. So these are the sort of things that I think probably many colleagues will have experienced, where something flies across your inbox and wants an answer yesterday. It does, however, seem likely that the export of legal education, either through the recruitment of international students to home institutions or the teaching of international students in their own countries, is likely to continue, and that a coherent institutional approach should be adopted. Of course, it might be argued that the average 3-year undergraduate law programme, such as is found in many institutions in England and Wales, is too limited in its scope to be able to accommodate any comparative dimension. There are, however, examples from abroad that could be used. For example, Katharina Pistor, talking about the introduction of comparative law at Columbia Law School and the adoption of comparative law in Michigan Law School, gives examples of teaching core subjects across multiple legal orders, so that while students may not learn about the whole of a foreign legal system, at least they become aware of the possibilities. Another approach by Bitas is that if a comparative approach is adopted from very early on, it has, as he states, the potential to sensitize students to the forces shaping the modern practice environment, while also giving them an appreciation of the fundamental grammar of external legal systems and of the expanded universe of options for problem solving. It might therefore be possible to structure the curriculum so as to provide for home students hoping to practice in a global environment at the same time as offering a legal education that is more sensitive to the legal environment of foreign students. Tam, for example, suggests that rather than focusing on micro-comparison, the comparative dimension of legal education should focus on legal development and the interaction of law and society, the court system and the constitution, occasionally drawing attention to certain landmark decisions that are illustrative of the particular legal culture. What he suggests is important is to understand global legal culture, not necessarily so as to arrive at harmonization, but to understand how and why people think differently. Barker, writing in Australia, has suggested that every law subject actually should tick 3 boxes. It should be able to deliver education on the evolution of municipal law in order to take into account the new realities of globalization. It should provide a comparison of specific areas of law in different legal systems and the extent to which global developments are driving towards harmonization and a convergence. If these goals are to be met, then a reconsideration of the role and function of comparative law and comparative law teaching may be needed. This has, of course, been much debated over the decades, but what is needed here is consideration of how the approaches and methods of comparative law can inform and enrich legal education in the 21st century legal environment. Of course, as a starting point, much may depend on the institutional aim of legal education, both for home students and the motivation for recruiting foreign students and the establishment of foreign campuses. Does the institution see itself primarily as a provider of academic legal education or professional legal education? Is the focus on the theoretical or the practical? Most law schools try to do all of these things. Jacob has suggested there are 3 possible aims of legal education: the training of legal academics, the training of legal practitioners, and thirdly, educating cultivated men and women. While the first is rarely the primary aim of legal education, at least in the UK, and certainly not at undergraduate level. We don't profess to train legal academics. Some of us will wonder if we were ever trained to be legal academics. The second, to train legal practitioners, if that is the main aim of a law school, and there are increasing pressures on institutions to go down that employability route, should really be viewed as the most inappropriate for overseas students. Because unless that legal education on offer is sufficiently outward-looking to embrace non-domestic alternatives, which is rare in undergraduate programs, then it isn't offering a customised form of legal education to those who will practice in a legal system that is not that of the common law in England and Wales. If the third is the main aim, then there is considerable scope for incorporating a range of modules beyond the foundation law subjects or teaching law in a greater variety of ways, including comparatively even at first-year level or in combination with other subjects. Whatever approach is chosen, it would seem that there are exciting and important roles for comparativists in today's legal education environment. So in this paper, I've tried to raise concerns about the export of legal education, in particular the undergraduate qualifying law degree. As a potentially problematic transplant, I have drawn attention to its shortcomings when planted in the legal soil, particularly of mixed jurisdictions. In the course of thinking about this paper, I've also been drawn to considering the suitability for domestic students in an increasingly international, global and transnational world of the typical undergraduate program. And that's led to thinking about the role of comparative law and comparative lawyers in contributing to institutional strategies for curriculum design of courses appropriate for foreign students at home and abroad and home students, using a number of possible models drawing on examples from other jurisdictions. This may require a reconsideration of the role and contribution of comparative law and comparative legal education in the contemporary climate. The researchers also identified the need to establish much more clearly what is the experience of returning overseas students once they get home to a different legal environment. In particular, there appears to be scope for further research into the role and influence of university legal education in the development of contemporary legal systems, especially where those systems are multijural or mixed. Until a clearer picture emerges regarding the consequences of some of these more recent initiatives in legal education, perhaps it should be recalled that the law has always been regarded as a tool of colonialism, and a refusal to consider the comparative strengths and weaknesses or advantages and disadvantages of any transplant is, I would suggest, an attitude of empire. There is the danger that the presumption may be made that the legal model on offer is the best and will be beneficial to the recipient, even at a cost. What I've sought to demonstrate in this paper is that one of these costs may be the integrity of the existing legal system, especially in host countries where that system is a mixed one, and the programme on offer does not seem to be sensitive to this. So, to comparative scholars, I would suggest that there is an opportunity, and indeed perhaps an obligation, to advocate the importance of comparative perspectives in contemporary legal education.